The next question was, can a licensed spiritual healer write a prescription for a biofeedback device? I answered this question. The response is no. A licensed spiritual healer is a very advantageous license to have because it gives you the right to address the spiritual aspects of that person's life and stress. This is outside the scope of many other practices unless you hold a specific credential for it. But it's not a license in healthcare, and that is who the prescription needs to be written by. Jim Turner's input was that remember that this is an instance that there are many licenses granted by the states. A marriage license, a driver's license, a plumber's license, those do not meet the requirements that the FDA is negotiating with the company. Prescriptions for biofeedback need to come from a licensed healthcare provider. A licensed spiritual healer license is not a healthcare license. The next question was, is there a form that's been created for a licensed practitioner to use for prescription writing for a biofeedback purchase? And the answer is yes. This is from a website, the Medical Biofeedback Association and Credentialing Board at http://m as in Mary, bacb.com. That's http://mbacb.com. Number 1, you place your name, the name of your business, address information, and telephone number at the top of the form. Number 2, you place the name of your patient on the blank line in the first sentence. You sign and date the form. You give this form to your patient, and for your protection, it is also suggested you keep a copy in your patient's file. The prescription can be written thus, quote, I hereby prescribe biofeedback services for, state the client's name, for the purpose of relaxation to reduce his or her stress and or pain. This prescription is valid unless the person named above suffers from a seizure disorder of any kind, wears a pacemaker, or suffers adverse reactions following biofeedback training. Include the date and your signature. That's the form. And make no mistake about it, this prescription form is just as valid as the pre-printed pharmaceutical prescription forms. But it does one thing that the drug company forms do not do. It places responsibility for the safety of the client in the hands of the person who accepts this prescription. When you sell a device to an unlicensed person, the distributorship and the manufacturer is accepting the prescription. The next question is, I'm assuming that a chiropractor can write a prescription for biofeedback. Is this true? And the response was yes. And I'd also add that as can licensed nurses, acupuncturists, psychologists, dentists, licensed massage therapists. The license held must be in the field of health. Now the next question is, what are the criteria for a licensed practitioner to approve a prescription for biofeedback purchase? And my response to that was that the person has to have the capacity to operate the device, or they have to have a family member who has agreed to, and does not wear a pacemaker, and or conservatively also has no history of seizures, and does not have a negative reaction to biofeedback. This is contained in the verbiage suggested for writing the prescription itself. The next question was, Native Americans can have a status of medicine man or woman. Can we write prescriptions, or do we even need to? The response from Jim Turner was that the entire issue of how Native Americans are regulated with regard to health is very murky. Many of the rules that we're referring to here do not apply to the Native American community, particularly when they are living on Native American land. The next question was, do these legalities apply to Puerto Rico? And the response was yes. The next question was, could you draft a form for writing a prescription that the prescription writers are held harmless? My response to this is that the suggested prescription form places the person receiving it and the manufacturer with the responsibility of disclosing whether or not they wear a pacemaker. That should absolve you from personal harm. We, the Quantum Alliance, accept the prescription for their personal use, and we follow up with the purchasers to determine whether or not they intend to become certified. The responsibility of communicating the education process is ours, and you are therefore absolved from harm on their actions professionally. Your prescription to them is for personal use. We provide them with scholarships for the certification training. The next question is, didn't the Washington State Board of Chiropractic ban the use of the EPFX? Therefore, chiropractors can't write a prescription. The response was that you need to be careful about how the boards do things. They have a series of statements in chiropractic boards that say, such as, this is experimental, or this is not found to be useful. Technically speaking, legally, the Chiropractic Board of Washington State, or any state, is very limited on what they can actually say about what you can and can't do legally. However, there are all kinds of internal struggles that take place in the chiropractic world. And if a group gets control of a board that doesn't like something, they're very likely to issue a statement or regulation against it. The question then becomes, how much of a risk do you want to take, and how much of a problem do you want to have with your board? Whether you can write a prescription or not, the question of writing the prescription has to do with the manufacturer. They can only sell the device to a qualified person, and from the manufacturer's point of view, they can sell to a chiropractor in Washington State, even if the chiropractic board states that they don't recognize this biofeedback modality. So what the chiropractor in Washington State does with that becomes a secondary question as far as the company's concerned. If the board tries to stop the use of the device, that becomes the choice of the chiropractor. Do they want to have that issue or battle, or do they want to use it anyway? The next question was, how can we say that a board can't hold a prescription writer liable when boards, such as the Washington Chiropractic Board, banned the use of the device by its members? And the response was that the issue of the board and its regulations have been covered. Now we need to see what they said and how they said it. There's a belief among boards that they have a lot more authority than they have, and they exercise their prerogatives as if they have a lot more authority than they do. They get away with it because the average practitioner is not about to take on their board. So a board can say, I don't like your shoes to be polished brown, and if you do, we're going to have a hearing about it. The practitioner says, okay, I'll just wear black shoes. That doesn't mean that brown shoes are banned under the law. Just that the politics of the situation says that this isn't worth fighting about. That situation exists in all the health boards across the country in all kinds of ways. It's a very unfortunate part of our American legal system. So if you're a chiropractor in Washington State and you want to use one of the devices, you meet the criteria. The FDA is regulating the manufacturer, who can't sell to somebody who's not qualified. And one way you're qualified is by having a healthcare license. If you want to turn around and sell it to somebody else, you have to sell it to somebody qualified. And the way that's organized by the company at this point is by the prescription process, which the FDA agrees with. If you want to determine how to deal with Washington State's chiropractic board, then we have to look at it as a very specific question. There are many devices that chiropractic boards in one part of the country, including Canada, will say are completely unusable and you can't use them. And then in other parts of the country, the boards endorse those same devices. It's that uneven. It's more in the realms of the politics of chiropractic rather than the realm of the law. Boards have usually responded when they are presented legal arguments about certain practices and devices being harmless and legal. I have no idea what the State Board of Chiropractic in Washington would say in the face of being challenged. Health boards in the U.S. are extremely arbitrary and very far outside the formal legal structure, and in fact, should probably be reined in substantially. You can petition the board to change what they said about the EPFX, stating, please remove this from the list of devices that are not appropriate, and then lay the reasons out. They then have to decide if they're going to stand by what they said or if they're going to engage in a fight. The more serious you look, the more serious they're going to have to consider how they're going to respond. They don't necessarily want to have a fight.